In Muslim personal law, the marriage has been known popularly as nikah, and this nikah is a contractual in nature, and here there is a agreement between the bride and bridegroom. There is an agreement between the bride and bridegroom with a consideration that can be called as a dower or meher. And with regard to the essentials of the valid marriage is only three things. That is, the parties they are competent to contract. That means they should be of the age of they should not be minors. That means in Muslim law, that is what is the age of minority. It is different from the common what you call the Majority Act. Here, if that means they should not have if they have crossed 15 years of age, then they are competent to get into married. And second aspect is they should not be insane persons. They should not be of unsound mind of in nature, and they should not get married under the prohibited degrees of relationship. So what is meant by prohibited degrees of relationship? So they are under prohibited degrees of relationship, mother, sister, all those people will come. Here, even though the Muslim marriage is contractual in nature, here with regard to the dissolution of marriage, with regard to the I can say with regard to the giving a divorce, the husband has got the more authority. That means he has got the higher authority. He has got the unilateral authority in divorcing his wife, except under few circumstances. So today we are going to deal with regard to the dissolution of marriage, where the husband, the Muslim husband, has got the higher authority with regard to what you call divorcing his wife. So today we are looking into the concept of dissolution of marriage. Here, with regard to the dissolution of marriage, we can look into there are two things are there. One is by the act of God, that is by the death of the husband or wife. Another is by the act of parties. Let us concentrate with regard to the act of parties. So here, under the act of parties, we can see there are three things, or primarily we can see, that is by talaq by husband. That means by husband, talaq can be given. That is talaq ul sunnat, talaq ul biddat, and ila and ziyar. And the other thing is by the mutual consent is kula and mubarak. And at the instance of the wife, it is tafiz. And other form of the dissolution of marriage is judicial divorce or decree. So here today in this video, let us concentrate only with regard to the talaq by husband and the separation by mutual consent. We can concentrate only with regard to this aspect, and with regard to the talaq by wife, that is talaqi tafiz, we can concentrate with regard to these aspects. In the next video, we can see the judicial divorce or decree. There we have to discuss the liyan and fask. So those things we can discuss in the next video. Today let us concentrate only with regard to the talaq at the option of the husband and talaq at the option of the wife, talaq by mutual consent. So here with regard to this one, here as I told you, there is the divorce is at the with regard to divorcing with regard to divorce, the husband has got the higher authority. That is at the instance of the husband, and only in the case of at the instance of the wife, so that means where she has got the delegated authority from the husband. So there we have to discuss with regard to the at the initials of the wife. And next one is divorce by the mutual consent. Here under these two things there is no intervention by the court or any other person or body or authority. Only with regard to the judicial divorce, their intervention of the court is required. Okay, here let us see with regard to the what is there with regard to the unilateral divorce. So it is at the instance of the husband, that will be called as a talaq. That means to the literal meaning of the talaq in the Arabic is that to release the animal. Here, when the husband exercises the right of pronouncing divorce on his wife, technically this is known as talaq. So here, when the husband exercises the right of pronouncing divorce on his wife, it will be called as talaq. Here, this is the most remarkable feature in the Muslim law of talaq, is that all the schools of the Sunni and Shias recognize it. That means here, even though there are some differences among the practice with regard to the giving divorce among Sunnis and Shias, but they have recognized this concept of talaq. Here, with regard to the absolute power of the Muslim husband of divorcing his wife lies unilaterally, without any cause, without assigning any reason, literally at his will. So, the absolute power of the Muslim husband in divorcing his wife, it is unilateral, it is possible. He need not have to assign any reason. So, here in Hanafi, he may, if he is under the intoxication also, if he gives the divorce, then also it is valid one. So, here this talaq may be oral or writing. So, under this table we can see there is a talaq by husband. There we can see one is talaqul sunnat and talaqul biddat. Here talaqul sunnat, it is a revocable in nature. That means here this can be called as most approved form of divorce. That means Prophet Muhammad has approved this form of the divorce with regard to the talaqul sunnat. There we can see there are two forms of divorce is there. One is asan and the hasan. Here with regard to the asan, it will be called as the most proper form of the divorce, and with regard to the hasan, it is a proper form of divorce. So it is which is in a revocable nature. Here with regard to this talaqul sunnat, Prophet Muhammad, he has considered this is the best form of the divorce, but he with regard to the talaq, Prophet Muhammad, he considered this talaq as an evil. So that's why he has not given much more importance with regard to talaq. But when the situation is inevitable, when the husband and wife could not lead the life under one roof, then it is proper to give the talaq. So that was the notion of the Prophet Muhammad. Let us consider this talaqul sunnat. Here, with regard to the talaqul sunnat, there are two forms are there, that is asan and hasan. Here with regard to the asan talaq, the asan talaq consists of the single pronouncement of divorce made in a period of tuhar. That means why this is a single pronouncement of the pronouncement of divorce made in a period of tuhar means here as in what we call according to Islam, this talaq is a evil word. It should not be repeated often and often. That's why it should be uttered only once. So here with regard to the talaq asan form of the marriage, it should be uttered only during the tuhar period. Here what is the tuhar period means? It is a period between the two ministrations. So here once the husband he utters this word with regard to the utters the what you call he utters the word talaq, then it will commences what you call the period of iddat also commences with the tuhar period. Here after this single pronouncement, the wife has to observe iddat for 3 monthly courses. So after this iddat period completion only, the talaq asan divorce will be completed. Here the husband is precluded from having the sexual intercourse with his wife. So if he has opted for the sexual intercourse with his wife, there will be revocation will be there. So cohabitation with the wife is itself called as the implied revocation of the asal form of the talaq. So that's why it will be called as a most proper form of the what you call the divorce, or most proper form of the separation. Because if the husband, if there is some time gap has been given between the husband and wife with regard to the separation, then there is a chance of reconciliation. That's why it will be called as a most proper form of divorce, and it will be called as best form of divorce also. So here, giving sufficient time to consider their decision, there will be either the husband or wife, they can settle the differences. So that's why it will be called as the best form of divorce. So here what we have to see, that is a pronouncement in a single sentence, and here the pronouncement should be pronounced at the time of the tuer period only, and if that period also starts with this along with this tuer period. So here there will not be no sexual intercourse with the wife. If any sexual intercourse has been taken place, then there will be revocation will be there. So this is with regard to the talaq asan form of the separation. Then we can go to the hasan form of the talaq. So what is the difference between hasan form of the talaq? Here with regard to the hasan form of the talaq, the husband has to make the what you call he can pronounce the talaq in 3 times in the successive tours. That means no doubt the husband can make the single declaration of talaq in a period of tour. That means the tour means that is a period between the 2 ministrations. So here the husband has to make a single declaration of talaq in a period of the tour. So here he has to make for each tour period he has to make the separate the declaration. So that is the difference between the talaq hasan and the talaq hasan. In talaq hasan, the husband has to make a single declaration, whereas with regard to the talaq hasan, the husband has to pronounce 3 times in successive tours. So that is the difference between the talaq hasan and the talaq hasan. So here the husband, when he makes the 3rd declaration only, the talaq will be completed. So same what you call the conditions will be applicable here also. Here if he has got the sexual intercourse with his wife, then also this hasan talaq form of separation will not be completed. Here the leading case with regard to the hasan talaq is Ghulam Muhyiddin versus Kaiser. Here what has happened? Husband has communicated his intention to separate from his wife on say 15th September, and he has what he has done from 15th September, next one is 15th October, next one is 15th November. So all this there will be 3 tuher period will come. It will continue. Then what he has done? He has written written talaq nama and he has communicated to his wife. Thereby he has taken the condition that there is a completion of the talaq. But the court has said that he has communicated the talaq on 15th September under the single declaration, and thereby 15th October, 15th November he has not communicated anything. So this will not be, the talaq has not been completed under the Hasan talaq. So that's why here independent declaration should be given under 3 tuhar periods. So that is the specialty of the talaq Hasan form of the divorce. That's why it will be called as the good form of divorce, whereas this Hasan talaq is called as the best form of divorce. So that is the difference between the Hasan talaq and the Hasan talaq. Next one is the talaqul biddat. So here, with regard to the talaqul biddat, it is not recognized under the Islam, but it has been recognized under legally. That means this aspect has been recognized legally, but it is not recognized under Islam. So according to Amir Ali, this mode of talaq was introduced by the Umayyad kings. That means the kings, they have brought this talaqul biddat. That is a prohibited form of divorce. Now our central government, our parliament has also, it has abolished this talaqul biddat. So here it is a irrevocable form of divorce, whereas this talaq Hasan and the talaq Hasan, this can be revocable, whereas with regard to the talaqul biddat, this is if the 3 declarations has been, either it has been made in one time or under the different occasions, it will become the irrevocable in nature. So this has been widely followed among the Sunni Muslims. So with regard to this one, it has been brought into effect by the Umayyad kings. So even though the Prophet's formula, it is with regard to this one, it is inconvenient to these kings. So that's why they have brought this sort of the talaqul biddat form of divorce. So this here with regard to this talaqul biddat, there is a famous case law is there, that is the talaqul biddat. In this case, there is a famous case law is there, that is Rahmatullah versus State of UP. Here, in this case, we have the facts of this case is that the Muslim couple, that is Rahmatullah and Katinusa, they have got the landed properties which is exceeding the Land Holdings Act of 1960 in the UP. So the authorities, they have given the notice to this couple that they are holding the lands more than the ceiling limit. For that one, Rahmatullah has replied that he and his wife, they have been separated. He has pronounced the talaqul biddat. So, and they are having the property within the ceiling limit. So the Land Holdings Act of 1960 is not applicable to them. Here the court has held that the lands were still the property of the couple because there was no divorce at all. Because here divorce through irrevocable talaq was not lawful because it was not recognized by the Quran. So here this stand has been taken by the court, and it has also held that this talaqul biddat, it is against to the principles of the Constitution of India. So, and it is against to the fundamental duties provided under Article 51 clause A, subclause A, and E, F, H. So likewise, it is against to the interest of the womanhood. So that's why for the purpose of Land Holding Act, this divorce of talaqul biddat is not applicable. It holds that there is no talaq among the Rahmatullah and the Katinusa. Here what we have to see with regard to the talaqul biddat, it is here it is not the approved form of the talaq. Here it is against to the Quran, and it is against to the interest of the Muslim wife. So that's why here it is for the convenience of the what you call some section of the society, it has been made. So that's why this has been held as the leading judgment. Now this talaqul biddat has been cancelled by the recent amendment, we can see with regard this one in a separate video with regard to this talaq will be that we can see the aspects of the with regard to the abolition of the triple talaq. Let us go further. That means here we have discussed with regard to the Hasan form of marriage, Hasan form of marriage. These are all the revocable in nature, and thereby we have discussed the talaqul biddat. It is irrevocable in nature. Then the next aspect is delegated divorce. That will be called as talaqi tafiz. So this can be called as a delegated form of divorce, whereby a Muslim wife has been delegated the power of divorce. Here, although the power to give divorce belonging to primarily to the husband, that means a Muslim wife has no independent right of divorce here, and the power to give divorce belongs to primarily to the husband. He may delegate the power to his wife or to even to a third person, either absolutely or conditionally. That means he may delegate this power of what you call pronouncement of what you call talaq either to anybody or to his wife. So here, and either for a particular period or permanently. That means it may be temporary or it may be permanent in nature. Here, the person to whom the power is thus delegated may then pronounce the divorce accordingly. That means here what we have to understand, even though the wife can pronounce the talaq, she is going to pronounce the talaq according to the delegated powers given by her husband. So that will be called as talaqi tafiz. So it can be a conditional also, and it may be for a temporary period and also for the permanent period. Here, temporary delegation of the power is irrevocable, but the permanent delegation may be revoked. So here temporary delegation is irrevocable in nature. That is the specialty of this talaqi tafiz. And here there are some case laws are there with regard to talaqi tafiz, with regard to the Sainuddin versus Latifunisa and Magila Bibi versus Nur Hussain. Here under Sainuddin versus Latifunisa, as I have told you, that is it may be conditional one. That means on happening of this certain condition, the wife can pronounce the talaq. That is delegated by the husband himself. So under this Sainuddin versus Latifunisa, what happened? The husband has delegated his wife to pronounce the talaq in the event of the marrying a second wife. So without the permission of the first, that is herself. So this will be condition on happening of the condition. So she has pronounced the talaq and it has come under the talaq tafiz. And here further, an agreement made whether before or after marriage, by which it is provided that wife should be at liberty to divorce herself in specified contingencies, is valid. Under the specified contingencies means under the specified what you call context. So she can set her liberty. She can set herself as a liberty, and if the conditions are of a reasonable nature and are not opposed to the policy of the Mohammedan law, when such agreement is made, the wife may at any time after the happening of any of the contingencies repudiate herself in the exercise of the power, and a divorce will then take effect to the same effect as if talaq has been pronounced by the husband. So that is the specialty of this delegated form of divorce. Here with regard to this one, with regard delegated form of divorce, it may be written one also. Here, as I told you earlier, this may be what you call it may be oral also, and it may be what you call it may be written also. That means talaq may be oral or it may be in writing also. If it is in writing, it can be called as talaqnama. Here, the talaqnama we have discussed this aspect in the what you call talaq Hasan form also. Here, with regard to this talaqi tafiz, here also in Magila Bibi versus Nur Hussain, the husband has authorized his wife with regard to the in the event if there is any cruelty on her, she's at the liberty to to pronounce the talaqi tafiz. So he has authorized that one. For that one, his wife has also signed for that document. Here, the court has said that it is not the bilateral document. So it will not the bilateral document, even though his wife has signed that one. That has been communicated by the husband only. And here she has found that there is a what you call her husband is not the what you call he is not is not the qualified the medical practitioner what he has projected at the time of the contract of his marriage. So that is also one of the reason, and she has been authorized by the what you call her husband only to pronounce this talaqi tafiz when he is cruel. So Magila Bibi, she has found that he is cruel and is what you call he is cheating him. He is cheating her. Then she has pronounced the what you call talaq tafiz, that is she has pronounced the talaq on behalf of the husband only. So this is the specialty of this delegated divorce, that is talaq tafiz. Then we can go to the next form of divorce, that is constructive divorce. So this is also very a special form of divorce. But we in India, this form of divorce we don't find in India. But it is also one of the form of divorce. Here what happened in ILA, a divorce by ILA is a species of constructive divorce. Here both are the species of constructive divorce only. Here which is affected by the abstinence from the sexual intercourse for the period of not less than 4 months. So here what happens? The husband, he takes the oath that he will not have the sex with the sexual intercourse with his wife. Then he will communicate his intention to get separated from his wife. So at that instance, that instance, it will be he intends to dissolve the marriage. So then the ILA will be in force for a period of 4 months. After the expiry of the 4th month, the marriage dissolves irrevocably. But if the husband resumes the cohabitation within the period of these 4 months, then ILA will be cancelled and the marriage will not be dissolved. But one the strange thing what we have to see with regard to this one, with regard to the Shia law, that is under Itana Ashariya Shia school, ILA does not operate as divorce automatically and without the order of the court of law. So after this what you call period of 4 months, then it has to, they have to get the divorce from the court also. So that is the thing we can see under ILA. But with regard to the GR, this is GR is a form of inchoate divorce, and here the husband compares his wife to mother or any other female within prohibited degrees of within the prohibited degrees. Here, what is the specialty of this GR is that it is also a form of a constructive divorce. In this mode, the husband compares his wife with a woman within his prohibited relationship. It may be mother or sister. So the husband may say that from today onwards, the wife is like a mother or sister. So here he will make the objectionable comparison, and he will he will not cohabit with his wife for a period of 4 months. Same period what we can see under ILA, here also there is a period of 4 months will be there. Then the marriage will be dissolved. Here these things we may see under the GR, and she may go to the court for a judicial divorce also. And in this GR, she may go to the court for an order for restitution of conjugal rights also. So here this sort of the what you call the rights has been created under the GR. Here the marriage will not automatically, it will not get dissolved. After the completion of this 4th month, the wife has got these rights. But if the husband thinks that he he has taken the what you call wrong decision and he wants to live with his wife. So for that one, he has to he cannot automatically he has pronounced, he has compared his wife with the mother or sister, and that happens to be sinful. And when he wants to live with his wife once again, then he has to make the penance. He has to make for his he has to make the penance. He has to pay the penalty. So that's why here the husband has to pay for his what you call his sinful act by way of a penance. Either he has to feed 60 poor persons, or he has to observe the fast for 2 months, or he can release a slave, or whatever the conditions put forward by the wife. This we can see with regard to GR. Here, the law of GR has now received statutory recognition under Section 2 of the Shariat Act of 1937. So here, this ILA and GR, which will come under the concept of the constructive divorce. So far, we have seen the talaq at the option of the husband. So here talaqul sunnat, we have seen the asal forum divorce and asal forum, that is revocable in nature. That means that can be revocable at any point of time, whereas talaqul biddat, that is irrevocable in nature. And further, we have discussed the talaq by husband, that is under ILA and GR. And with regard to the next aspect is at the instance of the wife. Even though wife she will use the talaq, so she has got the power to give the talaq by delegated by her husband. So here the wife can give the talaq the fees. Now let us see what are all the things there under by mutual consent, that is kula and the mubarat. Here with regard to the kula and mubarat, what is the meaning of kula? So here it is very much important to know the meaning of the kula and mubarat. So that will be considered under by mutual consent. Here by mutual consent, under divorce by mutual consent, this kula will be considered. The meaning of kula means, the literal meaning of the word kula means to take off the clothes. That means in law it means divorce by the wife with the consent of her husband on payment of something to him. So that will be called as kula. Here a marriage may be dissolved not only by talaq, which is the arbitrary act of the husband, but also by agreement between the husband and wife. Dissolution of marriage by agreement may take in the form of kula or mubarat. So I have told you what is meant by kula. Here kula is it can be by the divorce by the mutual consent, that by the husband and wife. Here a divorce by kula is a divorce with the consent at the instance of the wife only, and in which she gives or agrees to give a consideration to the husband for her release from the marriage tie. So in such case, the terms of the bargain or matters of arrangement between the husband and wife, and the wife may at the consideration release her dower. That means either she may not claim for her dower, that is due dower, that will be called as dynamar, dynmahar, or she can in certain cases if the husband asks for any settlement because for any payment of money, so that aspect also she has to meet it out. So in order to get her release from this marriage tie, the wife she has to make the bargain in matters of arrangement between the husband and wife, and the wife may as the consideration release or dower and other rights, or make any other agreement for the benefit of the husband. So here also the husband is somewhat is a beneficiary with regard to this kula form of divorce. So here one more thing we have to understand here. Suppose the wife she does not she does not stand up with her saying. Suppose she wants to give the property or money to the husband. Suppose she is in failure of doing that one, whether this kula form of divorce will be annulled. So it will not be annulled, but but the husband can file the case. Here, failure on the part of the wife to pay the consideration for the divorce does not invalidate the divorce, though the husband may sue the wife for it. That means he can sue his wife for non-payment of the money which has been agreed to give the kula, that is by the option of the wife. So here in this aspect, there is a leading case is there, that is kula, that is a kula. And with regard this one, there is a kula, there is a leading case is there, that is Munshi Buzul Rahim versus Lutifuna Nisa. Here the Privy Council has observed that kula is a form of divorce. So here a divorce of kula is a divorce with the consent at the instance of the wife, in which she gives or agrees to give a consideration to the husband for her release from the marriage tie. In such a case, the terms of the bargain are matters of arrangement between the husband and wife, and the wife may, as consideration, release her dynamar, that is due dower, and other rights, or make any other agreement for the benefit of her husband. So this is the thing we can see with regard to the kula, and there are certain aspects we have to see with regard to the valid essentials of the valid kula also. Here, for giving the what you call kula, there should be, the parties should be competent enough. That means what is competent? As I told you, the husband and wife must be sound mind. They have attained the age of the puberty, that is 15 years, and that is the first thing. And they should be in a condition to give the free consent, and the consideration is for her release, the wife has to pay the something to the husband as compensation, and any sum of money or property may be settled as consideration of kula, but there is no the minimum or maximum limit has not been said with regard to this kula aspect. So let us see what is mubarat. So this is also a form of mutual consent. Here under mubarat, it is also like a divorce like kula. Here mubarat is also divorce by mutual consent of the husband and wife. In kula, the wife alone is desirous of separation and makes the offer. Here with regard to the mubarat, the husband, there is a here both the parties are equally willing to dissolve the marriage. Here not only the wife, here husband also is willing to get separated from his wife. Here when the aversion is on the one side of the wife and she desires the separation, the transaction is called the kula. When the aversion is mutual, so when the aversion is mutual means if the husband and wife both they thought of getting separated, and both the sides desires a separation, the transaction is called the mubarat. The offer in a mubarat, divorce may proceed from the wife, or it may proceed from the husband. That means it may be proceeded from either of the parties, but once it is accepted, the dissolution is completed. So this is the aspect we can see under the mutual consent. So we have discussed the aspects concerning to the divorce at the option of the husband. So divorce at the that means here the talaq by the husband, that means divorce at the option of the husband, and here we can also see that the divorce the option of the husband, that is ilan jr, and the delegated power to his wife, that is at the option of the wife, that will be called as talaqi tafwis. And we have seen the by mutual consent, that means in the kula, the wife she wants to get rid of her husband. In mubarat, both the husband and wife they want to get separated, that is by mutual consent. One is at the option of the husband, another is at the both the parties, at the option of the both the parties, and another aspect, that is talaqi tafwis. There it is by the delegated powers of given to the Muslim wife, she can pronounce the talaqi tafwis. In the next video, we can see the judicial divorce or decree. So there we have to discuss the lian and first, and we can discuss the what you call the Parliament Act with regard to the talaqul biddat and triple talaq. We can discuss this aspect and this judicial divorce and decree in the next video.